life without parole sentence.
Okay. Are you familiar with People versus Ginther?
Yes.
All right. In all those cases that you did examine, did they have Ginther hearings?
That's a good question. I don't know the answer to that question.
Because that would affect whether it's, you understand Ginther gives
Oh,
you
sure,
the record.
absolutely. It gives you the ability to put on testimony at a hearing to establish that your attorney was ineffective.
Yes.
And the Michigan Courts of Appeals routinely do that when there's evidence of attorney malfeasance, yes.
Yeah. They routinely do what?
They will routinely allow a Ginther hearing if they suspect in any way that an attorney has not lived up to their professional standard of care.
And that is not easily granted.
Because attorneys, in most cases, do not act ineffectively. That's correct.
Oh, they don't. Thank you.
Thank you very much. We're always effective attorneys up here, so.
Good.
Right? Okay. Yeah. Any other questions from the House or Senate members here today?
Okay. And I would just, close that we are a resource, not only to this committee, but to the entire House and Senate bodies. So to the extent that you have additional legal questions after today's hearings or otherwise, feel free to call us at any time. We're here to help.
Kesto? Oh, thank you. Representative Kesto has a question.
Thank you, Mr. Chair. Thank you,
Sure.
sir. So just let me get this straight. Eighth Amendment, right? The court said that a life offense mandatory, that life without parole is not cruel and unusual.
That's correct.
Thank you.
They rejected that claim, 9-0.
But a mandatory life without parole is.
You have to have a hearing, correct?
You have to have a hearing. Did they talk about that, whether or not it's under the Eighth Amendment is invoked if it is a mandatory life without parole?
Whether they invoked the Eighth Amendment specifically for that ruling?
Yeah, whether they addressed it there.
Yeah, as Professor Thomas indicated, there were kind of these two strands. One were the Eighth Amendment juvenile cases. The other strand was mandatory sentencing. So there was kind of a confluence there. I don't know that you could specifically say that it was one or the other. But the end result was a process change.
Thank you. Representative O'Brien.
Thank you. This is just a follow-up with Representative Kesto's question. We're really talking two issues about retroactivity versus moving forward, and I think often we're treating them all as one. Do you have a specific position on moving forward prospectively, requiring the judges to review the Supreme Court decision when when allowing for sentencing of life in prison?
There's no question that going forward prospectively that you should have what we're all calling a Miller v. Alabama hearing and decide whether the crime is sufficiently culpable, sufficiently heinous to warrant the life without parole sentence. So I don't think anybody disagrees that prospectively that problem needs to be solved. There might be some disagreement about what the appropriate minimum term of years might be for that. I know that in the initial bill it was 15 years and then parole eligibility. Others have thrown out a 25 to 40, and the Attorney General's position today was more like a 35 to 50. The 35 years being tied to roughly half of a person's life expectancy as being kind of the minimum that you would want for the taking of a life. So I think everyone agrees going forward you need to solve that problem. Our view is just that retroactively you might as well solve the problem too by putting in this trigger so that you don't have to decide this issue again 3 years down the road in the unlikely event the U.S. Supreme Court goes the other way on retroactivity.
That's very helpful how you just summarized everything, because there's been a lot of discussion about whether we should deal with this issue now versus waiting a few years to deal with this issue. So I really appreciate you following up with the question and providing such a concise summary.
Yes, and in fact, the Court of Appeals in the CARP case specifically asked for the legislature's direction prospectively, and we absolutely encourage that.
Thank you. Let's also clarify another thing that I hear in the media quite a bit, and that is in the event retroactivity takes place, whether that is done by the legislature or by a future court decision, there seems to be an idea that retroactivity equals release. Walk me through that process. If we go the retroactivity route, is this fundamentally change the parole process, or are we looking at a specific resentencing hearing? What form do you think that would take?
Well,